Good morning. I'm Parole Officer Trisella, and I'm a hearing examiner for the Board of Pardons and Paroles. And this is a revocation hearing concerning Christian Rivera, inmate number 435710. Today is Thursday, March 20th, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office at MacDougall Correctional Institution. Can you please state your full name and DOC inmate number for the record?
My name is Christian Rivera, 435710.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is Attorney Famiglietti. Can you please identify yourself for the record?
Yes, good morning. Public Defender Robert Famiglietti of the Parole Revocation Unit. Hello, sir.
Hello, how you doing?
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to the appropriate sanction. The recommendation will then be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. Counsel, is it okay if I swear your client in?
Yes.
All right. The testimony at today's hearing will be taken under oath. So, Mr. Rivera, can you please raise your right hand? Do you solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes, I do.
Thank you. So we're going to go over the procedure for your hearing. So first, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find that you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
I do not.
So you do have important rights at today's hearing, and I'm going to review them with you now. You have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive a written notice of charges of violation. Did you receive the written notice?
Yes, I did.
Perfect. You have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. You understand these rights, and are you ready to go forward?
Yes.
So we're going to review the charges now that the state, your parole officer, is bringing against you, and the information underlying each charge. I am going to put on the record that no finding of probable cause was made at the preliminary hearing for part 1 and 2 of charge number 2, drugs. And a no finding was also made for Halfway House. So I'm going to omit those from being put on the record, as they were not taken into consideration for today's hearing, because Parole and Community Services has not submitted any additional evidence. So there's no reason to readdress them. So for charge number 1, condition of residence, the charging officer reported that on 1/22/2025 at 8:40 a.m. you signed out to go to a GED class at Career Resources and was scheduled to return at 12:30 p.m. You did not return to your approved address. At 1:55 p.m. you were contacted by House Monitor and stated that you were almost in a car accident and was on your way back to your approved residence. You never returned. Your whereabouts were unknown until you turned yourself in at the Bridgeport Parole District Office on 1/31/2025. On charge number 2, condition of drugs, the charging officer reported that on 1/31, that's the right one, right? You arrived and surrendered to this officer. You admitted to using heroin. You signed a voluntary admission form admitting to using heroin. And this puts you in violation of your signed conditions that specifically state through your period on parole, you're prohibited from the consumption of alcoholic beverages. You also violated your condition that states, I will not use or have in my possession or control any illegal drugs, narcotics, or drug paraphernalia, firearms, ammunition, and any other weapons. The evidence submitted for the preliminary hearing all remain the same. And again, I did not receive any additional evidence from the state at this point. So counsel, did you and your client receive the notice of parole violation, the parole violation report, and all the other evidence that was identified? Great. I also received an exhibit from the defense. I have exhibit 1, a list of parole accomplishments and future plans for parole reinstatement. Is that accurate?
Yes.
Do you need any additional time to submit other evidence?
No.
All right, so we do not have witnesses today. So it is the defense's opportunity to call any witnesses, present evidence, and to speak to the charge of and any of the evidence submitted. So
I have
counsel.
no problem. That's the preponderance standard.
Thank you.
He's on his way. We just had to track him down. He's on his way.
So I'm just gonna take a moment. It's my findings now. So for charge number 1, the condition of residence, I am making a finding based on exhibits B, E, and F. And for charge number 2, the condition of drugs, I'm also making a finding for part 3 dated 1/31/25 based on exhibits B, E, H, and I. So it does conclude the fact-finding portion of today's hearing. Before I make my recommendation, you will have an opportunity to speak to your background and history. And the purpose of this part of the revocation hearing is to help determine the outcome I will recommend. Counsel?
Yes. So on January 22nd, my client was out on a pass. Unfortunately, almost got into an accident. He relapsed. He was gone for about 7 days. He turned himself in on the 31st, and on that day admitted he had used heroin. He was only gone for 7 days. He received a sanction for one of the alleged positive urines and was referred for IOP, and that was on 1/8. Unfortunately, he barely started those classes before he was remanded. He had only 3 months left on parole at the time. I don't think that holding him till the end of parole is appropriate. I think what he needs is treatment. Holding him until 6/16 and then releasing him won't give him an opportunity to transition with some treatment under his belt. I think that this violation is not sufficiently serious enough to warrant further incarceration. He's already been held about a month and a half. We don't think further confinement is necessary or appropriate. He's a young man, single, 23 years of age, receives support from his mom and his fiancee, Wanda. He has 2 children, ages 8 and 10. He completed the GED pre-test through Career Resources, and he's eager to get back and further his education and obtain his GED. He was last employed doing construction and painting. He's completed an IOP, participated in an IOP at Recovery Network Programs, J Brothers. He has been in MAT, medication management, Optimus Healthcare for medical. He volunteered while at the Isaiah House. He volunteered to clean both in and outside of the program. He wishes to be placed in a halfway house in New Haven due to its proximity to his fiancee. I stated he wishes to further his education. He's amenable to all job opportunities, and he was offered a job at a Caribbean restaurant. He wishes to get professional help and wishes to successfully complete an intensive outpatient program to transition to inpatient and transition to outpatient program. I don't think this is a serious violation. I think it's important that he turned himself back in. He was forthright that he had relapsed. We'd ask that you consider that when recommending a sanction. We'd ask for the soonest possible date. Thank you very much for your time and consideration.
Thank you.
You're welcome.
Take a moment and I'll let you know my recommendation. I do just want to note a few things. So this is, Mr. Rivera is on discretionary parole. This is his second violation of this term of discretionary parole. For similar behavior. And with that being said, I am going to revoke his parole and recommend that he serves an approximate 4.5 month sanction with a no new re-parole date because his current end of sentence is June 16, 2025. So in the event the board decides to lessen my recommended sanction, I'm going to recommend the following conditions: halfway house placement, New Haven, a mental health evaluation, and no operation of a motor vehicle without parole officer's permission. So my recommendation will go to the board on April 3rd. And on that date, the board can do a few things. They can either lessen my recommendation or they can adopt it and let it stand. So you'll be notified after that date, April 3rd, of what their decision is by mail. We'll send you a letter, okay? Any questions on this?
So the hearing examiner is recommending you serve the rest of your sentence. On April 3rd, they can shorten that if they want to, or just have you serve the rest of your sentence. Call our office on April 4th and we'll let you know what happened, okay?
Okay.
All right, take care, sir.
This
Have a good
concludes the
one.
revocation for Christian Rivera, inmate number 435710. Thank you, Mr. Rivera.
All right.
Yeah.
You all set?
Good morning, Mr. Agron. We have the interpreter here to assist us today. Would you like to use an interpreter for today's hearing?
Speak English.
Buenos días, Mr. Agron. Ella le estaba preguntando que si necesitaba que utilizar mis servicios en el día de hoy para traducirle.
Sí,
Okay,
Sí.
so I'm gonna swear the interpreter in first. So, Ms. Rivera, can you please raise your right hand? You solemnly swear, solemnly and sincerely affirm, as the case may be, that you will faithfully discharge, according to law, your duties as an interpreter to the best of your abilities to help you God upon penalty of perjury.
I do.
Thank you. So good morning, I'm Parole Officer Trisello, and I'm a hearing examiner for the Board of Pardons and Paroles. And this is a revocation hearing concerning Johnny Agron, inmate number 405378. Today is Thursday, March 20th, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and MacDougall Correctional Institution.
Buenos días, soy la oficial Trucelo, examinadora de audiencias para la Junta de Indultos y Libertad Condicional. Esta es una audiencia de revocación referente a Johnny Agron, número 405378. Hoy es jueves 20 de marzo del 2025. Esta audiencia se está llevando a cabo a través de video en la Junta de Indultos y Libertad Condicional, localidad central y la institución correccional de MacDougall.
Please state your full name and DOC inmate number for the record.
Por favor, decir su nombre y número de confinado de DOC para el registro.
Johnny Agron, 405378.
Great. So this is a public hearing and public access to this hearing is available via video live stream. We're going to go over the purpose of today's hearing. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked And if I recommend revocation, I'll make a recommendation as to the appropriate sanction. My recommendation will be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement.
Esta es una audiencia pública. Acceso público a esta audiencia está disponible vía transmisión en vivo. Ahora hablaré acerca del propósito de esta audiencia. Esta es una audiencia de revocación para determinar si ha violado las condiciones de su liberación. Revisaré y haré hallazgos de hecho en cada uno de los cargos en su contra. El Estado, no usted, tiene la responsabilidad de probar las acusaciones mediante una preponderancia de evidencia. Es decir, la mejor evidencia o más pesada debe establecer que, más probable que no, la alegación es cierta. Si no encuentro que haya una preponderancia de evidencia que respalde una violación de una o más de las condiciones de su libertad condicional, restableceré su libertad condicional, lo que significa liberarlo y ponerlo nuevamente bajo supervisión. Si encuentro que ha violado una o más de las condiciones de su libertad condicional, consideraré si su libertad condicional debe ser revocada o no. Y si recomiendo la revocación, haré una recomendación en cuanto a una sanción apropiada. Mi recomendación se dará a un panel para una decisión final. Si el panel desea imponer una sanción más allá de mi recomendación, se proporcionará una audiencia suplementaria para justificar un confinamiento adicional.
So you should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Agron, can you please raise your right hand?
Usted debe saber que esta audiencia de revocación es un procedimiento adversario. Cualquier cosa que usted diga durante esta audiencia podría ser usado en su contra. Esta audiencia está siendo grabada. El testimonio del día de hoy será tomado bajo juramento. Señora Agron, si por favor puede levantar su mano derecha.
Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Usted jura solemnemente y sinceramente afirma, según sea el caso, que la evidencia provista en relación a este caso será la verdad, toda la verdad y nada más que la verdad, que así lo ayude Dios o bajo penalidad de perjurio.
Sí.
I will go over the procedure for the hearing now. So first, I'm going to read you your rights. Then we will review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find that you have violated one or more of the conditions of your parole, you'll have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
Para hablar sobre el procedimiento de la audiencia, primero voy a leer sus derechos, luego revisaré los cargos de violación a libertad condicional que el Estado, su oficial de supervisión, ha presentado en su contra. Luego revisaré e identificaré la evidencia presentada para el registro. El Estado no está presente en el día de hoy, por lo tanto usted tendrá la oportunidad de ofrecer testimonio y presentar evidencia en su caso, de ser necesario. Luego de considerar la evidencia presentada, anunciaré mis hallazgos. Si encuentro que usted ha violado una o más de las condiciones de su libertad condicional, usted tendrá la oportunidad de hablar acerca de sus antecedentes e historial. ¿Tiene alguna pregunta antes de comenzar la audiencia?
No, estoy bien.
Okay, great. So you do have important rights for today's hearing, and we're going to review them now. The first right you have is you have the right to be represented by an attorney at this hearing. You may hire your own attorney, and if you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Were you informed that an attorney could represent you at today's hearing?
Usted tiene derechos importantes en esta audiencia que ahora revisaré con usted. Usted tiene el derecho a ser representado por un abogado. Si usted no puede pagar un abogado, puede calificar para un abogado designado que lo represente. ¿Tiene intención de buscar un abogado para esta audiencia o desea proceder sin abogado?
No quiero seguir.
I will move forward without an attorney.
Okay, sounds good. So you also have the right to receive written notice of the charges of violation. You have the right to review did you receive that written notice?
Usted tiene derecho a recibir notificación por escrito de los cargos de violación. ¿Recibió usted notificación por escrito?
Sí.
Yes.
You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Usted tiene el derecho de revisar la evidencia en su contra antes de esta audiencia. Usted tiene derecho a presentar pruebas en apoyo a su caso. En esta audiencia usted tiene el derecho de llamar e interrogar a testigos voluntarios y de interrogar a testigos adversos. ¿Entiende usted estos derechos y está listo para seguir hacia adelante?
Sí.
Yes.
So we're now going to review the charges that the state your parole officer is bringing against you and the information underlying each charge. So for charge number 1, condition of absconder, the charging officer reported that on 7/12/24, you were placed at your only parole approved residence, the Eddy Center Halfway House located at 1 La Belle Circle, Middletown, Connecticut. On 7/13/24, you were transported to Middlesex Hospital to be dosed for your prescription methadone. At approximately 8:30 a.m., Halfway House staff contacted the hospital to check on you, and they were informed that you had discharged at 7:30 a.m. All attempts to locate you were unsuccessful, and you have made no attempts to contact the Halfway House or Parole, indicating your intentions to purposely evade parole supervision. Your whereabouts in the community have remained unknown since 7/13/2024.
Estaré leyendo los cargos que el Estado, su oficial de libertad condicional, ha presentado en su contra y la información subyacente a cada cargo. En el cargo número 1, fuga. El 12 de julio del 2024, usted fue ubicado en su única residencia aprobada por libertad condicional, Eddy Center Halfway House, localizado en 1 La Belle Circle, en Middletown, Connecticut. El 13 de julio del 2024, usted fue transportado a Middlesex Hospital para darle su dosis recetada de metadona. Aproximadamente a las 8:30 de la mañana, el personal de Halfway House contactó al hospital para ver cómo estaba y ellos fueron informados que usted había sido dado de alta a las 7:30 de la mañana. Todos los intentos de localizarlos fueron infructuosos y usted no ha hecho intentos de contactar a Halfway House o libertad condicional, indicando su intención de evadir deliberadamente la supervisión de libertad condicional. Su paradero en la comunidad ha permanecido desconocido desde el 13 de julio del 2024.
On charge number 2, condition of obedience to the law, the charging officer reported that on 8/28/24, you were arrested by New Britain Police. Current charges are 53A-167A, interfering with an officer resisting, and 53A-130, criminal impersonation. You were arraigned at GA15 at New Britain Court related to this arrest under docket number H15N-CR24-0350581-S. Your next court date is 9/6/2024. Based on your behaviors, you're in violation of your parole condition, obey all laws. I will obey all laws.
En el cargo número 2, obediencia a la ley, el 28 de agosto del 2024, usted fue arrestado por la policía de New Britain. Los cargos actuales son 53A-167A, interferir con oficial, resistirse, y 53A-130, suplantación criminal. Usted fue procesado en la Corte GA15 de New Britain bajo el expediente H15N-CR24-035081-S. Su próxima fecha de corte fue el 6 de septiembre del 2024. Basado en su conducta, usted está en violación de su condición de libertad condicional, obedecer todas las leyes.
And then for charge number 3, condition of drugs, the charging officer reported that on or around 7/12/24, you used fentanyl/norfentanyl.
En el cargo número 3, drogas, en alrededor del 12 de septiembre del 2024, su oficial reportó que usted usó fentanyl and norfentanyl.
The state has filed the following exhibits that have been marked for identification purposes as Exhibit A, the remand to actual custody order, Exhibit B, the signed parole conditions, Exhibit C, the notice of parole violation and parolee rights, Exhibit D, the parole violation report, Exhibit E, the Halfway House agreement, Exhibit F, the Eddy Center incident report dated 7/12/24, Exhibit G, the Quest Diagnostic Drug Monitoring Report, collection date 7/12/24, Exhibit H, the Eddy Center incident report dated 7/13/24, Exhibit I, the Board of Pardons and Paroles preliminary hearing summary dated 5/10/22, Exhibit J, the Board of Pardons and Paroles revocation hearing summary dated 2/15/24, Exhibit K, the Board of Pardons and Paroles violation report dated 6/30/24, Exhibit L, the New Britain Police Report, case number 24-023483, and Exhibit M, the Connecticut Judicial Branch pending case detailed docket number H15N-CR24-0350581-S. Do you want to go to the addendum? Do you want to do that? Go to the addendum. In addition, the state has filed 2 addendums to the parole violation report, and both are also being admitted into evidence. The first was submitted on 8/30/2024 and states that on 8/7/24, the Board of Parole issued a warrant based on the report declaring Agron an absconder from special parole supervision. On 18/8/24, New Britain, police arrested Agron on the charges of 53A-167A, officer resisting. And 53A-130, criminal impersonation. The second addendum was submitted on 2/19/2025, and that states that the criminal case related to the respective charges under the docket number H15N-CR24-0350581-S have been resolved as of 2/14/25. The charge of interfering with an officer resisting was nullied, and the charge of 53A-130 criminal impersonation was found guilty, sentenced to 6 months in jail, and that Mr. Agron has no other pending charges at this time.
El Estado ha sometido la siguiente evidencia para fines de identificación: exhibición A, orden de regreso a custodia; exhibición B, condiciones firmadas de PCS; exhibición C, aviso de violación a libertad condicional y derechos de persona en libertad condicional; exhibición D, reporte de violación a libertad condicional; exhibición E, acuerdo de Halfway House; exhibición F, reporte de incidente de Dessasure con fecha de julio del 2024; exhibición G, reporte de monitoreo de droga después de Diagnostics con fecha de colección del 12 de julio del 2024; exhibición H, reporte de incidente de Edith Center con fecha del 13 de julio del 2024; exhibición I, resumen de audiencia preliminar del Board of Pardons and Paroles con fecha del 10 de mayo del 2022; exhibición J, resumen de audiencia de revocación del Board of Pardons and Paroles con fecha del 15 de febrero del 2024; exhibición K, reporte de violación de BOPP con fecha del 30 de junio del 2024; exhibición L, reporte de policía de New Britain, caso número 24-023-483; exhibición M, detalle de caso pendiente de la rama judicial de Connecticut, expediente H15N R24-035081-S. En adición, el Estado ha sometido 2 anexos al reporte de violación de libertad condicional y ambos han sido admitidos como evidencia. El primero fue sometido el 30 de agosto del 2024 e indica que el 7 de agosto del 2024 BOPP emitió una orden de arresto basado en el reporte declarando a Agron de supervisión de libertad condicional. El segundo anexo, el cual fue sometido el 19 de febrero del 2025, indica que el 8 de agosto del 2024 usted fue detenido por la policía de New Britain y acusado criminalmente. El caso criminal relacionado a estos cargos bajo el expediente que culmina en 0581 ha sido resuelto el 14 de febrero del 2025. Sería el 53A-167, interferir con oficial, resistirse, fue nully, y el 53A-130, suplantación criminal, fue encontrado culpable y sentenciado a 6 meses de prisión. Hasta el momento no hay otros cargos pendientes.
Mr. Agron, did you receive the notice of parole violation, the parole violation report, and all the other documents that have been identified for today's purposes?
Mr. Agron, usted recibió el aviso de violación a libertad condicional, el reporte de violación a libertad condicional y los otros documentos que mencionamos en el registro.
Sí.
I have not received any documents from the defense. Is that accurate, Mr. Agron?
No he recibido ningún tipo de documentos para la defensa. ¿Es esto correcto?
Ajá.
No.
No me acuerdo. No me acuerdo.
I do not remember.
Did you submit any documents for today's hearing?
¿Usted llegó a someter algún documento para la audiencia de hoy?
No.
Do you need any additional time to submit any evidence for today's proceedings?
¿Necesita algún tiempo adicional para someter algún documento?
No.
So we do not have any witnesses. So at this time, it is your opportunity to respond to the parole violation charges against you. However, I want you to remember that you may remain silent if you choose to do so. So at this time, you may call and question any witnesses or testify regarding your case. So do you have any comments, Mr. Agron, towards the charges that have been brought against you?
No hay testigos en el día de hoy. Ahora esta es su oportunidad de responder a los cargos de la violación de libertad condicional en su contra. Sin embargo, usted sabe que puede permanecer en silencio si así lo desea. También puede llamar a presentar evidencia o testificar en relación a su caso. ¿Desea hacer algún comentario en relación a la violación en su contra, señora Agron?
No, está bien.
No, I am okay.
Okay, so I am going to then announce my findings. So for charge number 1, I do find that you violated the condition of absconder based on the evidence presented in exhibits B, D, and H.
Ahora voy a hacer mis hallazgos en el cargo número 1. Fuga, encuentro que usted violó la condición basado en la evidencia provista en relación a este cargo, exhibiciones B, D y H.
On charge number 2, I find that you violated the condition of obedience to the law based on your conviction of criminal impersonation, Connecticut General Statute 53A-130 on 2/14/2025, when you were sentenced to 6 months in jail. And in addition, the evidence provided support the charge, which is states exhibits B, D, and L.
En el cargo número 2, encuentro que usted violó la condición de obediencia a la ley basado en su convicción criminal de suplantación criminal, Estatuto General de Connecticut 53A-130, en el 14 de febrero del 2025, cuando usted fue sentenciado a 6 meses de prisión en adicción a la evidencia del Estado, exhibiciones B, D y L.
And then on charge number 3, I do find that you violated the condition of drugs based on the evidence presented in states exhibits B, D, F, and G.
En el cargo número 3, encuentro que usted violó la condición de drogas basado en la evidencia provista en relación a este cargo, exhibiciones B, D, F y G.
So that does conclude the fact-finding portion of today's hearing. Before I make my recommendation, you will have the opportunity to speak to your background and history. The purpose of this part of the revocation hearing is to help determine what outcome I will recommend. So, Mr. Agron, would you wish to make a statement regarding your violation, the background and/or history at this time?
Con esto concluye la parte de determinación de hechos de esta audiencia. Antes de hacer mi recomendación, usted tendrá la oportunidad de hablar acerca de sus antecedentes e historia. El propósito de esta parte de la audiencia de revocación es ayudar a determinar qué resultado recomendaré. Mr. Agron, ¿desea hacer algún comentario acerca de sus de los cargos o de sus antecedentes en este momento?
No.
So I'll just take a moment and I'll let you know my recommended sanction.
De un momento y le voy a dejar saber mi sanción recomendada.
So I have listened to the testimony today and I've reviewed all the evidence provided. And based on that, Mr. Agron, I am going to recommend your parole be revoked and that you have a no new re-parole date, as your special parole end date is May 24th, 2025. So that is an approximate 9-month period of confinement. In the event that the board decides to lessen my sanction, I'm going to recommend the following conditions, which is no contact with co-defendant BGS and halfway house placement.
He escuchado el testimonio y revisado la evidencia provista. Basado en esto, recomiendo que se revoque su libertad condicional sin una nueva fecha de regreso a supervisión, ya que su fecha de culminación de supervisión especial de libertad condicional finaliza el 24 de mayo del 2025, lo cual es un periodo aproximado de confinamiento de 9 meses. Si la Junta desea disminuir mi sanción, recomiendo las siguientes condiciones: no contacto con el coacusado BGS y ubicación en halfway house.
So my findings and recommendation we forwarded to the board on April 3rd, 2025. On that date, the board can do 2 things. They can adopt my recommended sanction or they can lessen it. You will be notified with their written decision shortly after that date in April.
Mis hallazgos y recomendaciones se emitirán a la Junta. Usted recibirá una decisión oficial por escrito. La revisión de la Junta está programada para el 3 de abril del 2025. Esa fecha pueden suceder 2 cosas: que la Junta adopte mi sanción recomendada o que deseen disminuir la sanción recomendada. Usted va a recibir toda esta documentación por escrito.
Do you have any questions right now, Mr. Agron?
¿Tiene alguna pregunta, señora Agron?
Mi fecha de terminar mi sentencia es en mayo, ¿vale?
My DOS date, it's in May.
Yeah, that's also the end of your special parole. So it's May 24th, 2025. You will no longer be on supervision and you'll EOS. You'll be done with prison time.
Si es el final de su sentencia, el 24 de mayo del 2025, lo cual significa que también es el final de su fecha de supervisión. Después de esa fecha ya usted ya habrá terminado su sentencia completa.
And that's my recommendation. The board makes the final decision.
Y esa es mi recomendación, que terminaste esta fecha, pero la Junta va a hacer la decisión final.
Okay, the only other thing that can happen is you get out before that May date. That's the only thing other thing that can happen in April.
En su caso, única cosa que puede suceder es que salga antes de tiempo, si ellos así lo desean.
Any other questions? Are you all set?
¿Alguna otra pregunta? Ya sería todo, señor.
No, está bien, gracias.
This concludes revocation for Johnny Agron, inmate number 305378. Thank you, Mr. Agron. You're all set. Good luck to you, okay?
Thank you, gracias.
Thank you.
Gracias. Ya, gracias.
Good morning, Officer Grant. How are you?
Good morning, I'm well.
Good. So we'll start at 10 o'clock with Mr. Dessasure. I'll call over to Cybulski probably in about 20 minutes, okay?
Okay, perfect.
Thank you.
You're welcome.
Good morning, how are you?
Good morning.
Good morning. Good morning. We cannot start until exactly 10 o'clock. It's 9:55 right now, so we're just gonna wait about 5 minutes, then we'll get going, okay?
All right.
All right. Hey, good morning. Officer Grant, are you with us? Perfect. Awesome. All right, so good morning. I'm Parole Officer Trissello. I'm a hearing examiner for the Board of Pardons and Paroles. And this is a preliminary hearing concerning Shakiem Dessasure, inmate number 429-296. Today is Thursday, March 20th, 2025, and this hearing is being conducted via video at the Board of Pardons and Parole Central Office and Cybulski Correctional Institution. Can you please state your full name and DOC inmate number for the record?
Shakiem Dessasure, 429-296.
Thank you. So this is a public hearing and public access to this hearing is available via video live stream. Present this morning is Parole Officer Grant. Officer Grant, can you please identify yourself for the record?
Hi, I'm Parole Officer Grant.
Thank you. So this is a preliminary hearing which has three purposes under Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violated the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I'll reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So Mr. Dessasure and Officer Grant, can you please both raise your right hands? Do you solemnly swear, solemnly, sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Yes.
Thank you. Can you put your hands down? So the procedure for today's hearing will go as follows. First, I will read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits filed for the record. The state will then have an opportunity to address the issue of probable cause and the severity of the allegations. And after the state is finished, you will have the same opportunity. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin? No? Can you say it out loud, please? We're recording.
No, I
Thank
do
you.
not.
Thank you. So you do have important rights at the hearing today. The first right you have is the right to be represented by an attorney at today's hearing. You may hire your own attorney, and if you cannot afford an attorney, you may qualify for an appointed attorney. Were you informed that an attorney can represent you at today's hearing?
Yes.
Are you, do you intend to seek counsel for today's hearing?
No.
So you're willing to move forward today without any legal representation?
Yes.
You also have the right to receive the written notice of charges of violation. Did you receive the written notice?
Yes.
Good. You also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
All right, so we're now going to review the charge that the state your parole officer is bringing against you and the information underlying the charge. So Officer Grant, can you please read the charge number 1, condition of halfway house, the violation you submitted against Mr. Dessasure?
Yes. On February 21st, 2025, at approximately 3:45 p.m., you engaged in a verbal altercation with Chase Center's job developer, Rivera, when he instructed you to reschedule job interviews due to the request being last minute and on the weekend. You are aware that all passes will need to be verified by staff. You became upset and started demanding J.D. Rivera to explain to you why you could not go on an interview. J.D. Rivera instructed you to leave his office after noticing the conversation was getting out of hand. He instructed you to leave his office multiple times over the course of 2 minutes. At 3:39 p.m., you responded, "Or what?" when directed to leave. At 3:40 p.m., you continued to talk to J.D. Rivera through the door once it was closed. You stated, "You are a hoe. What the fuck are you talking about? Soft ass nigga," and proceeded to walk away. While walking away from the office, you continued to make verbal threats. You stated, "The fuck you talking about? I'll smack the shit out of that nigga." You violated the halfway house agreements Specifically, I will treat others with respect and not engage in verbal or physical altercations with other offenders, staff, or third parties.
Thank you. You have also filed exhibits that you've marked for identification purposes. Can you please identify the exhibits you submitted?
Yes. The exhibits are a remand to actual custody, parole violation report, parole signed conditions, halfway house agreement, parole and community services incident report dated February 21st, 2025, a temporary surrender dated February 21st, 2025, misdemeanor summons dated February 21st, 2025, probable cause determination request, CPS incident report case number 2500067354. Interstate Commission for Offender Supervision violation report requiring retaking. Interstate Commission for Adult Offender Supervision response to violation report. Interstate Commission for Adult Offender Supervision returning to sending state requesting for reporting instructions. Interstate Commission for Adult Offender Supervision violation report requiring retaking. Massachusetts Parole Board preliminary hearing summary. Massachusetts State Police incident report case number 2023-0B3009002, the notice of parole violation and the notice of parole right.
Thank you. Mr. Dessasure, did you receive the notice of parole violation, the parole violation reports, and all the other documents that were just identified?
Yes.
And were you able to review this information?
Yes.
So I have not received any exhibits from the defense. Is that accurate, Mr. Dessasure? Have you submitted any evidence on your own behalf?
No.
Do you need any additional time to submit evidence for today's hearing?
No.
Okay, so we don't have any witnesses today. So at this time, it is the state's opportunity to make a short statement, call any witnesses, and testify with respect to probable cause and the severity of the allegations. So Officer Grant, would you like to make any comments towards the charge?
So, in reviewing the case with job developer Rivera and the staff that witnessed the incident, Dessasure was seen outside of job developer Rivera's office making the comments stated in the charge. Therefore, we remanded him after the Connecticut State Police went to the halfway house and provided him with a summons for disorderly conduct. At that time, it was breach of peace. At that time, we remanded him and transported him to Hartford Correctional. On Saturday, February 22nd, I received a call from the trooper letting me know that the judge did not find probable cause. On February 24th, I issued another remand to Hartford CC, changing the charge from a criminal charge to a technical violation of special parole.
Okay. Any other comments?
No.
Okay, thank you. Mr. Dessasure, sorry, this is now your opportunity to respond to the charges against you. However, I want you to remember you do have the right to remain silent if you choose to do so, okay? So would you like to call any witnesses or testify to your case at this time, Mr. Dessasure?
Yes.
Okay, go ahead.
As she stated, the violation report, what she said is that approximately that I had the altercation. First, I did have an altercation with him, and it didn't go out of line, but I never done that. And it said in the violation report that due to the
Mr. Dessasure, can you wait 1 second? Miss Benedict, I'm having, do you hear that, Miss Benedict? It's very choppy. I just want to make sure I get everything you say.
I do. It sounds like the audio from Cybulski is choppy at the moment.
So just deal with it.
We can wait a moment to see if it's just a network thing that resolves. If
Okay.
it persists, my solution would be to have Cybulski leave and rejoin and see if
Okay.
that helps.
Okay, great. So yeah, so that's been about a moment. All right, go ahead, Mr. Dessasure. I might stop you again if I can't get everything you're saying, okay?
all right.
All right, go ahead.
So it says that I engaged in a robot police chase chasing the job development for Rivera when instructed to reschedule the job interview due to request being last minute on the weekend. But then the police came and took their report. It says that Rivera had that on February 21st, 2025 at 1700 hours, Rivera gave a written statement. Rivera stated, I, Rivera, I'm a job developer at the Chase Highway on February 24th, 2025 at about 3:30 p.m. She came to the shore, inmate number 429296, informed me that he had two job interviews scheduled for Saturday, 2/22/2025. This one stated that they were in Windsor and Fairfield consecutively. I informed him that it was too far to do consecutive interviews the same day. He left my office. Returned a few minutes late after the scheduled interview. I explained again why I could not, and he went to speak to a supervisor.
Mr. Dessasure, I am going to stop you. I can't, I'm trying to follow you. I want to hear what you're saying. Can you grab the CO for us? Right, Miss Benedict, that's the best solution.
At this moment, I would just try if we can, I could do it from my end, if we just hang up and reconnect to Cybulski and see if that resolves it.
Yeah, because I need to hear what he's saying. Thank you. Hi, sorry about that. We're getting it really choppy on our end, so we're going to disconnect right now and then I'm sorry, Kristen, we're going to send another request.
Yeah, I'm going to disconnect from Cybulski, and then in about 60 seconds, you'll get a new pop-up on screen if you can just accept that, and we'll see if it resolves the audio issue.
Thank you.
You're welcome.
If we could just do an audio check from your end to see if we can hear you clearly, Mr. Dessasure.
Yeah.
Hello.
I think that sounds better. Right, what do you think? All right, we'll try it, and if not, officer, if it doesn't work, we'll just call you in again, okay?
Okay, sounds good.
Actually, it's a lot better. Okay, thank you. All right, Mr. Dessasure. So I really did try to follow hard. So I had the violation notice in front of me, and I noticed that you pointed out the last, being last minute on the weekend. So do you mind starting back there?
All right.
Because I do want to make sure I have everything that you're saying. So sorry, I know you were all in your thing. So yeah, so I highlighted that part that you pointed out the violation, correct?
Yeah, it says that I was instructed that I had to reschedule the job interviews due to requests being last minute on the weekend. But when he spoke with the police officer that came, that wasn't the story he gave the police. He said that I couldn't go on the interviews because I couldn't go on, and I informed him that that was too far away to do consecutive interviews the same day. I left his office. It says he left my office and returned a few minutes late, asking again for me to schedule the interviews. I explained again why I could not, and he wanted to speak to a supervisor. I told him to leave my office, and he refused until he spoke with a supervisor. And this basically, he's trying to stay in the violation report. It's like I just got mad because he told me I had to reschedule my job interviews. It's been multiple occasions where I told him I had job interviews, and he said, oh, you couldn't go, you can't go. And on this day, on the next day, I had 2 interviews that I previously told him about weeks ahead of time, the week before. And he told me to come to him the day before to schedule the interview. And I did that, and he denied me. And I explained to him, like, by you not allowing me to go to interviews, is like on my Indeed account is showing bad activity. And I told him that I wasn't going to be in the halfway house for, I suppose, 30 days, and then I was supposed to return back to Massachusetts. And I was trying to find employment closer to there so that I didn't have to quit my job and that I only worked for a week because I was returning home. And I tried to tell him, like, I just want to speak to a supervisor. He kept refusing me the opportunity to speak to a supervisor. And I admit, like I said before, the conversation did get a little out of hand, and I did use some curse words towards him, but I never threatened him and said that I was going to put my hands on him or anything. I've been in a halfway house before, and I was already there for like 18 days. I wouldn't do nothing to mess up me going home within 12 days. I did get a little angry because it was like a constant thing with him. Like, he kept on denying me the opportunity to go to job interviews because, oh, they're too far, or it even got to the point where he told me, oh, I know you're not going to get the job, and denied my job interview. So I did get a little upset because I felt like he was hindering me from seeking employment and just not giving me the fair chance. But besides that, and then it even says again in the police report, Dessasure explained that he only had 30 days left in the halfway house before he was going to be transferred to Massachusetts Special Parole. So he was trying to get a job in Northern Connecticut so that he would not have to give up when he was transferred to Mass. I was just trying to, and it says, I spoke with Dessasure, who admitted that he had gone into Rivera's office and gotten frustrated that he was not allowed to go on interviews and was not told who else to speak to over Rivera. It wasn't like I just got mad because I had to reschedule or couldn't go on my interviews. It's because I was trying to speak to somebody higher up ahead of him, and he wasn't giving me the opportunity to do that. So I feel like he was just like saying, oh, no, you can't do nothing. Like, and I couldn't even fight my case or even ask anybody else who could potentially give me the opportunity to go on those job interviews.
Thank you. I do appreciate your comments. Any additional comments from anyone before I make my findings?
No, I'm fine. That's all I really wanted to say.
Okay, no problems. Officer Grant, any additional comments at this point before I do announce my findings?
Do you want me to read the parole violation report? The narrative?
No,
No, that's
I've read
fine.
it. It's been given.
Okay.
Thank you.
No
Any
other
new- anything
comments
new?
from me.
Okay, thank you. And Mr.
You're welcome.
Dessasure, one more time, you're set. I can move forward with the findings.
Yes.
Okay. I'm gonna take one moment. So for charge number 1, the condition of halfway house placement, I am gonna make a finding of probable cause based on exhibits B, C, D, E, and H. However, I believe that the behavior is not serious enough to warrant a revocation or any additional confinement, as you have been incarcerated for almost a month at this point. So I am going to reinstate your parole as of today. So I will let the records office know at the facility, and Officer Grant is now aware of it, so she will work on that on her end. And that does conclude the hearing. Does anybody have any questions at this point? Everyone's
No.
good?
Yes,
Okay.
thank
Okay, so this does conclude the preliminary hearing for Shakiem Dessasure. Mr. Dessasure, you actually said it yourself. Just think about what's important. I know it's frustrating, but I mean, you have an end game on this, just get there. Try to get there, all right?
All right,
There's just
thank
better
you.
ways to conduct it, and that's just my recommendation to you, because you're close to the end. I think, right, October, November, I'm not sure. Is it
Yes,
this year?
November
Yeah,
9th.
so just try to think better before you react. Make it easy in the next few months for yourself, okay?
All right, thank you.
Okay, this does conclude the preliminary hearing for Shakiem Dessasure, MA number 429-296. So you're all set. Like I said, I'm gonna work on the paperwork now to get it over to who it needs to for your release today, okay?
All right, thank you.
All right, thank you. Thank you, Officer Grant.
Thank
Have a
you.
good day. Yeah.
Hello. All right. How is everybody doing today? Just starting it up right now, a little bit late on the late train, if you will. Hey, what's up, Donna? Hello again from the UK. Hell yeah, that's what I'm gonna talk about right there. Represent your city. Hey, what up, Barbie? Hey, gracias. Appreciate that that heart. Let me see. I'm gonna finish setting up this Board of Parole hearings. And this is Connecticut, for those of you that are wondering. Hey, what's up? How's it going, Winter Hunter? Winter Hunter, if you will. What up, Christine? How's it going? Let me see. CT board hearings. Parole. Hey, thank you, Angel. Gracias a ti. Let me see here. Here we go. Switch my background up. Okay. What up, Jeb? How's it going today? How are you doing today? All right. So right now we're just waiting for the next individual to come up. I'm not sure how long, at what time. What time is it right now? 7:54. I'm assuming they'll probably be starting up at 8. So in about 6 minutes, but let me confirm. Let me look at the schedule right now. So right now it is, what is it? What time is it right now? I'm good. I can't complain. I got to go back to work today. Other than that, everything's fantastic. Let me see here. So right now it is, in New York, it's 10:54. So the next one's starting at 11. So yeah, it'll be starting in 6 minutes, hopefully, if they're on time. If they're not, then we'll be sitting around here listening to me blabbing away, if you will. Let me see. While I do that right now, let me just I'm gonna set up the vertical YT stream. Okay, we got it. Let me see. I've been saying "if you will" all the time now. Oh no. They'll be like, what court proceedings have you been listening today? Hey, what up, Tita? How's it going? All right. And if you're on the bigger account, as you can see, I still got the green screen going on, so you might want to switch it up to the smaller channel. Let me see. Hopefully, they're on time. Hopefully, right, Eric? Let me see. Hey, James, how is it? Hey, you know what? Hey, Hillary, I can't complain. Hey, I got up today without any back pain, so that's always a good day. Hey, thank you, Purple. Highly appreciate that. What up, Baz? How's it going? Let me see. Homegirl, just listening to you, laughing out loud. Hey, thank you for sending the heart. Tells Marie, if you will. Hey, Jerome, gracias. Highly appreciate it. It's that Felicia. Hey, what up, Felicia? How's it going? Welcome to You Have a Collect Call From. What up, Kim? Welcome. Let me finish up setting this thing up over here, because if not, I'll get sidetracked. Because I got that attention span of a squirrel, if you will, and I'll forget. Trust me, I'll forget. All right. So I've been streaming since 6 in the morning. What is it? It's about to be 8 already. Let me see. What up, Green Eye Bandit? What's on the schedule today? So right now we're waiting for Connecticut to start up. Let me see. It's let me look at the schedule here. So right now in Connecticut, it's 11. So we have, let me see, 1, 2, 3, 4. We got 4 more people coming up on this hearing here. The next individual coming up should be Simeon, spelled Simeon. Last name is gonna be an interesting one. Let me see, Wiguenson. That's gonna be you guys might want to look these people up before they come up, so like that you know exactly what we might be getting in today. Last name is gonna be spelled Wiguenson. Offender number 423177, and I'll look them up right now. And to see if
morning.
Okay. Here we go.
Yeah. Hello, how are you?
Hi, how you doing?
Good. I think we just have one, right? Whistnant?
Yes.
All right, thank you.
You're welcome. Come on in. Yeah.
Oh, that
You're
was it. Did I read out the right one? What? All right. Maybe I said the wrong name. I'm not sure. We'll see what they're talking about right now. All right. And if you're on the bigger channel, as you can see, you see me here, and then you see this other individual here. It's because I took a picture. See, laughing out loud. I see 2 of you. That's right. Hey, I need an extra me to be able to keep up with the shenanigans over here of the streaming and whatnot. Vertical. All right, that is good right there.
Hi, what's your name?
Daniel Lee Whistnant.
Perfect. So, Mr. Whistnant, it's 10:27. I have to wait until exactly 10:30 to start, okay? So in about 3 minutes, we'll get going. All right.
I told you. What was that fool's name? That was him, right? Yeah. Forget about it. His name is weird. We'll just leave it at that. I'm going to look him up right now. What do you guys think he did? What do you guys think he's in prison for? Let's see. Connecticut arrest. Let's see here. Is that a donkey and a toilet? That's no bueno. Let me see. Bridgeport, the police department, incident, arrest. This is Connecticut. This would be Connecticut. Morning, bro. What up, V2 Honda DV? Right. OG Smiley. Test 38. Let me see here. Hey, thank you for that, Angel. Highly appreciated. All right, wasn't able to pull anything up in him, so I guess we just have to wait here in anticipation till they spill the beans here and let us know what it is. Oh man, where the hell is my? Let me see here. I gotta find my. I recently did an update on one of these apps that I use here, and my icon disappeared from my from where I normally keep it. So let me add it back. It does make my life a little bit easier to be able to find these applications at my fingertips. Hey, what's up? Shout out to the 6 of you that are watching on YT. Highly appreciate that. How many being seen today? So I think in this one here, I want to say we got another, I think I said 4 more people. Let me see. I think he heard someone. And I know the color's a little bit off on this one because I do have a cheap phone that I'm using. So that's why it looks all bright. But I got to switch it up. Let me see here. Let me activate this one. Hey, thank you for that. Hey, thank you for that, Angel. Highly appreciate it.
Hey, good morning. I'm Parole Officer, that is my name, Tricello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Daniel Whistnant and 3715.
Daniel Whistnant, what the what?
Thursday, March 20th, 2025, and
What's going on with the
be
audio?
conducted via video at the Board of Pardons and Paroles Central Office and Osborn Correctional Institution. Can you please say your full name and DOC inmate number for the record?
Inmate number 253715, Daniel Lee Whistnant Jr.
Thank you. So this is a public hearing, and public access to this hearing is available via video live stream. Present this morning is your attorney, Attorney Sirica. Can you please identify yourself?
Attorney Alfonzo Sirica, Public Defender with the Parole Revocation Unit, on behalf of Mr. Whistnant.
This is a thank you. Sorry, this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. And if I recommend revocation, I will make a recommendation as to the appropriate sanction. A recommendation will then be given to a panel for a final decision. And if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. Counsel, can I swear your client in?
Yes, please.
All right, this testimony at today's hearing will be taken under oath. So, Mr. Whistnant, can you please raise your right hand?
Mr. Whistnant.
Do you solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God or upon penalty of perjury?
Yes.
Thank you. So you put your hand down, thanks. So we're gonna go over the procedure for today's hearing. The first is I'm gonna read you your rights. Then we're gonna review the parole violation charges that the state, your parole officer, is bringing against you. Also then review and identify exhibits filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I'll announce my findings. And if I find that you have violated one or more of the conditions of your parole, you will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
Okay, so we're going to go over your rights for today's hearing. The first is that you have the right to be represented by an attorney, and counsel's here present for you. You also have the right to receive a written notice of the charges of violation. Did you receive that written notice?
Yes, ma'am.
Perfect. So you also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes, ma'am.
We're now going to review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. So on charge number 1, condition of GPS, the charging officer reported that on 11/5/24, you failed to charge your GPS device for 2 hours, resulting in your GPS shutdown from 11/6/24 from approximately 12:05 p.m. to 3:08 p.m. in violation of your GPS agreement. Counsel, I'm just going to skip over the descriptions of the agreements. Is that all right? On 11/25/24, you failed to charge your GPS device for 2 hours, resulting in your GPS device shutting down on 11/26/24 from approximately 4:37 p.m. to 8:57 p.m. in violation of your GPS agreement. On 12/18/24, you removed your GPS device without permission from your parole officer in violation of your GPS agreement condition. For charge number 2, the condition of drug testing, on 12/10/24, you were instructed by halfway house staff to render urine, but refused to provide a sample. Charge number 3, condition of absconder, on 12/18/24, you failed to return to Renaissance East halfway house from Community Pass. You failed to contact your parole officer or the halfway house. Subsequently, you removed your GPS device without authorization. Local hospitals and police departments were contacted with negative results. Your whereabouts in the community remained unknown. Charge number 4, condition of drugs. On or about 12/18/24, you used opiates. Charge number 5, condition of no consumption of alcoholic beverages. On or about 10/22/24, you used alcohol. On or about 12/11/24, you used alcohol. On or about 12/17/24, you used alcohol. And charge number 6, condition of halfway house placement. On 10/22/24, you exited the Renaissance East halfway house on an approved pass to the reentry program, but never attended, which is a violation of your halfway house agreement. I'll read the whole thing. Stating, I will only go to locations indicated on the approved community pass unless changes have been authorized by staff. On returning to the halfway house, you stated instead of attending the reentry program, you went to visit a friend. You admitted to drinking alcohol during this time in violation of your special parole conditions. On 11/25/24, you were issued a pass from Renaissance East halfway house to attend an intake for adult education. The intake coordinator for adult education informed the halfway house that you never showed up for your scheduled appointment, which is in violation of your halfway house agreement condition. I will only go to locations indicated on an approved community pass unless changes have been authorized by staff. Upon review of GPS data, you appeared to walk around the city of Waterbury and returned to the halfway house later than permitted without contacting them, which is in violation of your halfway house agreement condition. I will return to the halfway house from a community pass at my scheduled return time. If I'm unable to do so, I will call the program staff to explain why I am expected to be late and receive a new return time. On 11/26/24, from approximately 4:37 p.m. till 8:57 p.m., your GPS device was shut down while you were in the community on a pass to attend adult education. The intake coordinator for adult education informed the halfway house staff that you did not show up for your scheduled appointment, which is in violation of your halfway house agreement, stating, I will only go to the location indicated on an approved community pass unless changes have been authorized by staff. Your whereabouts in the community on 11/26/24 were unknown due to the GPS shutdown. On 12/18/24, you failed to return to the halfway house from a community pass. You failed to contact your parole officer or halfway house staff, which is in violation of your halfway house agreement, stating, I will return to the halfway house from community pass at my scheduled return time. If I'm unable to do so, I will call program staff to explain why I am expected to be late and receive a new return time. Your whereabouts in the community remain unknown. The state has filed the following exhibits that I have remarked for identification purposes as Exhibit A, the remand to custody, Exhibit B, the notice of parole violation, Exhibit C, the parole violation report, Exhibit D, the conditions of parole, Exhibit E, the GPS agreement, Exhibit F, the halfway house agreement, Exhibit G, the misconduct/voluntary admission, 10/22/24, Exhibit H, the halfway house IR/DR/voluntary admission, 10/22/24, Exhibit I, misconduct GPS, 11/6/24, Exhibit J, the halfway house IR deviating 11/25/24 and 11/26/24, Exhibit K, misconduct GPS, 11/25/24 and 11/26/24, Exhibit L, GPS charge history, Exhibit M, the misconduct positive alcohol, 12/11/24, Exhibit N, the lab tox screen at 12/10/24, Exhibit O, the misconduct positive alcohol/opiates, 12/18/24, Exhibit P, the voluntary admission alcohol, 12/17/24, Exhibit Q, the lab tox screen, 12/17/24, Exhibit R, the lab tox screen, 12/19/24, Exhibit S, the halfway house IR failure to return to program, and Exhibit T, the Allied Universal Event History GPS strap violation, 12/18/24. In addition, the state filed an addendum to the parole violation report on 1/28/2025 that's also admitted into evidence and reads as follows. In reference to the parole violation report submitted by P.O. Spinelli regarding Whistnant Daniel number 253715, the following applies. On 1/15/25, the Board of Parole issued a warrant based on that report declaring Whistnant an absconder from special parole supervision. Of note, this is Whistnant's third time absconding since 3/10/2022. On 1/17/25, the case was assigned to Parole Officer Pinto for investigation. On 1/28/25, Whistnant was apprehended by the Parole Fugitive Investigation Unit subsequent to a short foot pursuit. On 1/28/25, a remand to custody order was lodged with Hartford Corrections. On 1/28/25, Whistnant was served with his parole violation notice and parolee rights at Hartford CC. Counsel, did you and your client receive the notice of parole violation, the parole violation report, and all the other documents that have been identified? Great. And I also received an exhibit from the defense. I have a list of parole accomplishments and future plans for parole reinstatement, correct?
Yes.
Do you need any additional time to submit other evidence? So at this time, then, we do not have any witnesses. So it is the defense's opportunity to call any witnesses, present evidence, and speak to the charges and any of the evidence submitted. So counsel?
Yes, if I may, just briefly sum of the charges. Daniel, on charge number 1 under GPS, the shutdown on November 5th of 2024 indicates a 2-hour shutdown from approximately 12:05 p.m. to 3:08 p.m. Did you notify your parole officer about any issues with your unit for that particular date, for November 5th of 2024?
Quick couple of days after it happened.
You did advise your PO there was an issue with the unit, correct?
Yes, he came to the halfway house and gave me a written
Misconduct?
huh?
He gave you a misconduct for that one?
Yeah.
Okay.
I couldn't go out for like a week.
Oh, wait, okay. The November 25th of 2024, it indicates you failed to charge your GPS for 2 hours, resulting in a shutdown from 11:26:24 from approximately 4:37 to 8:57. If I may examine Chisholm, Exhibit J, it indicates that my client, in the description of the incident, I'm halfway down. This is on 11/26. Client signed out to attend adult education at 4 p.m. So if the shutdown was from 4:37 to 8:57, my client leaves the halfway house at 4 o'clock, according to that exhibit, and returns at 7:40. I'm not sure it's supposed to carry a charger with that time frame, and he's back prior to the unit shut down at 8:37. So he's accountable according, we're going to take that evidence into consideration, that time frame. Do you understand what I'm saying?
Yeah.
He leaves at 4 and he gets written up for not charging from 4:37 to 8:57, but he's back at 7:40. Okay, just want to bring that to your attention regarding that particular shutdown. Regarding the removal of the GPS unit without the permission of the parole officer, my client that is in admission on 12/18, that did occur. He had been having some troubles with the director at the halfway house. He had asked to be removed and placed in another halfway house. Ms. Daniel, could you let her know what occurred the day prior on December 17th?
Yeah, I went to parole on December 17th because my parole officer wanted me to go there because I caught a dirty urine for alcohol and opiates and stuff. And I told him that day that I ain't want to be in the halfway house. And I kept on telling him that me and the director, Lewis, was having problems in the halfway house. And all I wanted to do was go to school and get my manufacturing, but I kept on telling my parole officer that me and Director Lewis was having a problem. I already told my parole officer. That's probably why I ran and stuff.
Okay, and what else happened where there was you given a statement to a particular police department on December 17th? What happened?
I got robbed December 16th. And I told my director, and he got like he didn't want to believe me. So the job coordinator, Nate, he brought me. Jasmine, a case manager, brought me to the police station. And I wrote a police report that I got robbed from my phone. And
which police department? Not to cut you off, Dan. Which police department did you give your statement to?
Waterbury, Connecticut.
Okay, thank you. Just on charge number 5, under the no consumption of alcoholic beverages, indicates he used on October 22, 24, December 11, 2024, and 12/17/24. He clearly had been struggling with that. Exhibit M does indicate though that my client in the interim there, under interventions and sanction, was instructed to report on 12/12. He was given a breathalyzer and urine. The offender tested negative for alcohol and drugs. So there was a claim. I just want to bring it to your attention. He's been struggling with that, but he did also, they tested him on 12/11. I think because he tested positive for alcohol. The following day, I just want to note that for the record, he tested negative for both alcohol and drugs on 12/12. All right. Under halfway house placement, just below the 11/25/24 allegation. As written by the parole officer against my client, it indicates on 11/25/24, you were issued a pass from Renaissance East halfway house to attend an intake for adult education. Intake coordinator for adult education informed the halfway house that you never showed up for your scheduled appointment. Exhibit J indicates that at 11/25/26, he signed out to go to adult ed for 4 p.m. Upon contacting the school, intake coordinator, Ms. Abney, was made aware that 11/25, client called the school at 4:30 p.m. to say he was lost. He was told to come back the following day. He returned back to the halfway house. At 11/26, client signed out to attend adult ed at 4 p.m. and was not able to register due to no identification. Client did not return until 7:40 p.m. Then it says, upon speaking with the testing coordinator at adult education, client arrived at the school at 4:30 p.m. on 11/26. The second block there for the parole violation reports indicating the intake coordinator for adult education informed the halfway house, this is for 11/26, you did not show up again for your appointment. That says he was there at 4:30. Contradicts what my client is charged with. So asking you to take that into consideration. This doesn't line up with the incident report, which is Exhibit J. Okay. That is my comments regarding the first part of their hearing. And I am asking you to consider making no findings on those parts that I brought to your attention, which factually don't line up with the evidence provided by the state. Thank you.
Thank you.
I'm assuming the GPS and the halfway house placement are going to be marked as part 1, 2, whatever they go. Okay.
Yeah.
Just got to make sure for record keeping purposes.
So I am gonna make my findings now. So for charge number 1, the condition of GPS, I am making a finding that you violated this charge based on state's exhibits C, D, E, I, K, L, and T. Charge number 2, the condition of drug testing. I'm also finding that you violated this condition based on the evidence in C, D, and M. For charge number 3, the condition of absconder, I'm making a no finding based on the credibility of the evidence submitted. There's evidence that states Mr. Whistnant's whereabouts in the community became unknown on 12/18. But he signed paperwork and submitted toxicologies after that. So that will be all written in the summary, counsel. On charge number 4, I found that you violated the condition of drugs based on states exhibits C, D, and Q. On charge number 5, I also found that you violated the condition of no consumption of alcoholic beverages based on state's exhibits C, D, G, M, and Q. On charge number 6, I have also identified this as for parts. So for parts 1, 2, and 4, I am making a finding that he violated the condition of halfway house placement based on exhibits C, D, F, H, J, K, and S. For part number 3, dated 11/26/24, I'm making a no finding, as the state did fail to submit sufficient evidence in support of the charge. So that does conclude the fact-finding portion of today's hearing. Before I make my recommendation, you will have an opportunity to speak to your background and history. And the purpose of this part of the hearing is to help determine what outcome I will recommend. Council, would you like to make a?
Yes, if I may, before I start, if I may, Daniel, I just want to clarify, so for charge number 3 under absconder, she made a no finding, so that charge is not gonna be used against you, okay? And under halfway house placement, part 3, there was a no finding, which is for the 11/26 date. The evidence doesn't line up with the allegations against you, so no finding made on that charge. You understand that?
Yes, sir.
Can I clarify something for
Yes.
Council? Even though I made a no finding, it doesn't negate from the.
I understand. I just want to explain to my client with no finding made.
Got it. Good?
Thank you,
Okay.
yes.
Awesome.
All right, on behalf of Mr. Whistnant, my client's 44 years old. He does have 4 children. On his previous release, he was at the Connecticut Renaissance Halfway House Program in Waterbury. He was attending the adult education his GED. He was due to start a job at Dunkin' Donuts in Waterbury, and in his previous job, he did work 2023 Rich Products in Britain. He did report to us, participated in outpatient mental health group once weekly in Wellmore in Waterbury. And was also establishing his primary care services over in Wellmore. He is working in the kitchen there, started in February. It's a 7-day-a-week job there in the facility. He is amenable to being placed at halfway house in Hartford. That's the area where the support system is. Does want to obtain his GED and does wish to enroll in manufacturing or a CNC machining program. He's amenable to any job opportunity. Is indicated to us he does have an opportunity at Trader Joe's in Bloomfield through his cousin who is employed there, and is amenable to any treatment recommendations in the community. So he's had some time to obviously, think about what happened here. He is trying to take advantage of the programs in the facility. He is working and he does have a place lined up for when he gets out, and a job also. Thank you.
Thank you. I'm just gonna take a moment. I'll let you know my recommendation. Okay. So I did listen to today's testimony. I've also reviewed all the evidence presented. Based on that, Mr. Whistnant, I am going to recommend your parole be revoked and that you serve an approximate 1-year period of confinement. That's with a re-parole date. That 2025. 1 second. Just off by then. So January 28th, 2026. With that, I'm going to recommend the following conditions: no alcoholic beverage consumption, no contact with the victim SW, mental health evaluation, no contact with minors, problem sexual behavior treatment, and halfway house for Hartford. Again, I did state to council already, but even though the no finding was made for absconder, doesn't mean that he was not reporting during that time. He still was not reporting to his officer. So that was taken into consideration with this. So with that, my recommendation is going to go to the board on 3/27/2025. No, it's not. Jeez, sorry. April 3rd, 2025 is when it's going to go to the board. On that day, Mr. Whistnant, the board can do a few things. They can adopt my recommended sanction. They can lessen it if they choose to do so. And if for any reason they would want to increase it, there will be a supplemental hearing scheduled, which you will be present for to address their concerns, and they'll review what their thoughts are with that with you, okay? At this time, do you have any questions?
No, ma'am.
All right, so Daniel, it's going to the board on April 3rd. You and I will get something in writing about 7 to 10 days after with the final outcome. If there's an issue with them adopting the recommendation, I'll set up another call with you. Okay, good luck to you.
This concludes
Yes.
the revocation for Daniel Whistnant and number 253715. Good luck, Mr. Whistnant.
Yeah, you too.
Sure.
Yeah, thank you.
Thank you.
Thank you.
Bye-bye.
Hey, good morning. I'm Parole Officer Trisella, and I'm a hearing examiner for the Board of Pardons and Paroles. And this is a revocation hearing concerning Simone Wiguenson, inmate number 423-177. Today is Thursday, March 20th, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office. Counsel is present this morning to represent Mr. Wiguenson. Counsel, can you please identify yourself?
Attorney Alfonzo Sirica, Public Defender with the Parole Revocation Unit on behalf of Mr. Wiguenson. I am waiving his presence. I did meet in person with my client on March 7th of 2025 at Garner Correctional Institution with the Creole interpreter regarding his revocation hearing, which was scheduled for today. After discussing the matter with my client has elected to waive the revocation hearing that was scheduled for today, based mostly on his EOS date of May 20th of 2025. But my client did understand that he could have went forward today. He elected to waive his hearing today, so we're officially waiving the revocation hearing for Simeon Wiguenson, inmate numbers 423-177.
Thank you. So I am going to accept counsel's waiver of today's hearing on the record, and I am going to make a finding of preponderance of evidence for both the charges. With that, I'm also going to make a recommendation to revoke Mr. Wigenson's parole with a no new re-parole date, as his current end of sentence is 5/20/2025. Actually, I did not check that today. Do you think it's less? Nope, 5/20/2025. That's with a no new re-parole date, as his current end of sentence is that date, which is an approximate 7-month sanction. In the event the board does decide to lessen my sanction, this will go to them on April 3rd as well, April 3rd, 2025. I am going to recommend the following conditions: no alcoholic beverage consumption, mental health evaluation, and halfway house placement. Do you have any conversation about that, counsel, in case if this does happen?
Yes.
Oh, I have that.
I'd like to be placed in the, looks like the
Oh, yes.
house of the Dennis house in
So I'll just do New Haven.
Yes.
If that does happen. So, again, this is going to go to the board on 4/3/2025, and they will make the final decision. Thank you. So this does conclude the revocation hearing for Simone Wiguenson, inmate number 423-177. We good, Miss Benedict? You became big on my screen. There you go.
You are good. You became big on your screen for just a moment.
Just checking. Saw something different. I appreciate you as always. Hi.
Warren, I should have him in here shortly. Raiford?
Awesome. Perfect. Yep, it's just Mr. Raiford. Thank you. Hi, Officer Johnson. How are you?
Is she from Iga?
All right, I'm waiting for York. I put my camera on by accident, sorry.
No, that's okay. So, yeah, I'm gonna go into York at 11:30, but I've had counsel here all morning, so I'm gonna do his case first.
That's totally fine.
Yeah, so as soon as we're done with the first one at York, we'll jump into Miss Fitzgerald, okay?
Yeah, very good. Hey, Attorney Sirica,
Yeah.
I know your brother.
Oh, lovely. All right. We'll chat. We'll chat.
Bye.
Bye.
I just knocked on the glass for the dog.
All right, thank you, yeah. Good morning. Man.
Good morning. I am Parole Officer Trisella, and I'm a hearing examiner. Yeah, you can hear me, right, Mr. Raiford?
Yes,
Yeah.
loud and clear.
Okay, perfect. I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Alex Raiford, inmate number 363662. Today is Thursday, March 20th, 2025. And this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and Corrigan Correctional Center. Can you please state your full name and DOC inmate number for the record?
My name is Alex Raiford, DOC number 363662.
Thank you. So this is a public hearing and public access to this hearing is available via video live stream. Present this morning is Attorney Sirica. Can you please identify yourself for the record?
Sure. Attorney Alfonzo Sirica, Public Defender with the Parole Revocation Unit, on behalf of Mr. Raiford for his preliminary hearing.
Thank you. So this is a preliminary hearing and it has three purposes under Connecticut law. The first is to determine if there's probable cause to believe you committed an act that violated the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. The third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there's a probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. Counsel, can I swear your client?
Yes, please.
The testimony at today's hearing will be taken under oath. So, Mr. Raiford, can you please raise your right hand? You solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God or upon penalty of perjury.
I do.
Thank you.
Yes.
So we're going to, yes, perfect. You can put your hand down. Thank you. We're going to go over the procedure for today's hearing. First, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits for the record. The state is not present at today's proceedings. However, you will have an opportunity to address the issue of probable cause and the severity of the allegations. And at the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No. No.
So you do. Okay, you do have important rights at today's hearing. Okay, and I am going to go over them with you now. You have the right to be represented by an attorney, and counsel is present for you. You have the right to receive the written notice of charge of the violation. Did you receive that notice?
Yes, I did.
Okay, you also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses, and you have the right to cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Absolutely.
Okay, so we're now going to review the charges that the state, your parole officer, is bringing against you and the information underlying each charge. So on charge number 1, condition of curfew, the charging officer reported that on 3/3/2025, you failed to be home for your 8 p.m. reach curfew. Instead, you're at Wiguenson Casino in the early morning hours until of 3/4/2025. You violated your reach agreement to be in the apartment by 8 p.m. nightly. Subsequently, you're in violation of parole condition 1, release direction, abide by curfew. On charge number 2, condition program participation, on 3/3/2025, you failed to be home for your 8 p.m. reach curfew. Instead, you were at Wiguenson in the early morning hours of 3/4/2025. You violated your reach agreement to be in your apartment by 8 p.m. nightly. Subsequently, you're in violation of parole condition number 1, release direction program participation. On charge number 3, condition of obedience to the law, the charging officer reported that on 3/4/2025, you were at Wiguenson Casino and were asked to leave numerous times by the Mohegan Tribe Police. After failing to comply with the police directions, you were placed under arrest and taken into custody. You were charged with criminal trespassing in the 1st degree. Subsequently, you were in violation of parole condition number 2, obey all laws. And charge number 4, condition of no consumption of alcoholic beverages. The charging officer reported that on 12/23/24, you were returned back to the halfway house and smelled of alcohol. You were given a breathalyzer on a red .05. You admitted to drinking a Mike's Hard Lemonade and signed a voluntary admission form. Subsequently, you were in violation of your parole condition number 7. You were prohibited from the consumption of alcoholic beverages. On 9/23/24, you returned back to the halfway house at 6:00 p.m. but failed to enter the building. You finally entered on 9/24/24 at 12:30 a.m. You rendered a urine and was given a breathalyzer test, which tested positive at .128. You admitted to drinking alcohol and signed a voluntary admission form. Subsequently, you're in violation of parole condition number 7. You're prohibited from the consumption of alcoholic beverages. On 9/21/24, you returned to the halfway house and appeared to be under the influence of alcohol. You rendered a positive breathalyzer and positive specimen. You admitted to your parole officer in the halfway house that you did drink 5 cans of Steel Reserve. Subsequently, you're in violation of parole condition number 7. You're prohibited from the consumption of alcoholic beverages. On 6/5/24, you rendered a urine that came back positive for alcohol. Admitted to your parole officer that you drank Smirnoff Ice on 6/4/2024 and signed a voluntary admission for. Subsequently, you're in violation of parole condition number 7. You're prohibited from the consumption of alcoholic beverages. On 5/23/24, you returned to the halfway house and you smelled of alcohol. A breathalyzer test was administered and the reading was 0.110. You admitted to your parole officer that you drank Smirnoff Ices on your way back from work. You signed a voluntary admission form stating you drank alcohol. Subsequently, you were in violation of parole condition number 7. You are prohibited from the consumption of alcoholic beverages. On 5/14/2024, you admitted to drinking a wine cooler the day before and signed a voluntary admission form. Subsequently, you are in violation of parole condition number 7. You are prohibited from the consumption of alcoholic beverages. The state has also filed the following exhibits that have been pre-marked for identification purposes. I have Exhibit A, remains in custody. Exhibit B, parole conditions. Exhibit C, a notice of parole violation. Exhibit D, the parole violation report. Exhibit E, decision form. Exhibit F, the Mohegan Tribe Police Report 25-00004201. Exhibit G, the connection reach client participation contract. Exhibit H, the misconduct/voluntary admission of use quest lab results for alcohol use on 12/23/24. Exhibit I, the misconduct/residential incident and discipline report voluntary admission for alcohol use on 9/23/24. Exhibit J, the misconduct/voluntary admission of use/quest lab results for alcohol use on 9/21/2024. Exhibit K, the misconduct/voluntary admission use for alcohol on 6/4/2024. Exhibit L, the misconduct/voluntary admission/residential discipline report/quest lab results alcohol use on 5/23/2024. And Exhibit M, the misconduct voluntary admission form for alcohol use on 5/13/2024. Council, did you and your client receive the the notice of parole violation, the parole violation report, and the other documents that have been identified?
Yes,
I have not received any exhibits from the defense. Is that accurate?
that's accurate. It's just a preliminary hearing.
Got it. So today we have no witnesses. So it is now the defense's opportunity to respond and make a short statement, call me witnesses, and testify with respect to probable cause.
Yes, regarding Mr. Raiford, as I did speak to my client 2 occasions, I did go over the preliminary hearing and what the parameters are as far as the board of parole. Did elect to have his hearing this morning. I am going to ask you to consider, we're not disputing the charge number 3. There is a case pending in court, but I'm going to put some comments on the record regarding the actual charge. And I'm going to ask you to be considering the seriousness of the offense regarding whether he should be held pending further revocation proceedings. So with that being said, I'm going to take these out of order also. Under charge number 2, on the program participation, I'm going to be asking that no finding be made on that charge. The language that is used, in my opinion, does not meet the elements of the program participations that's in the Board of Pardons and Parole policy, the manual that I have, which gives me each definition. My opinion is that charge number 2, program participation, the language that my client is charged with doesn't meet the elements there. Regarding charge number 4, the no consumption of alcoholic beverages. I just want to put on a record, my client was paroled on March 27th of 2024, was not remanded until March 4th of 2025, almost a year. He was out in the community. Those allegations on charge number 4, they go from December 23 of 2024 to May 14th of 2024. It was obviously in the community. Those technical violations for testing positive for alcohol did not result in my client being remanded. The issue occurred on March 4th. So everything, March 3rd and March 4th is basically why my client is currently locked up. Okay, so he was out for almost a year. We're not disputing there was some issues with the positive test. Regarding the obedience to the law charge, this incident occurred at the Wiguenson. My client was asked to leave. The allegation is that he didn't leave, thus resulting in an arrest. He's been at the facility since March 4th of 2025. When they brought him there, There are some issues with the way my client was processed regarding the criminal charge, and my client has been advised that needs to be dealt with in criminal court. But what I do want to, what's important here is the second part, once again, for the preliminary hearing regarding the seriousness of the charge. My client was given a non-surety bond, so that kind of tells me it's not that serious right out of the gate, because if it was a serious charge, there would have been a bond put on by the Wiguenson Tribal Police. He was scheduled to appear in court on March 13th of 2025 in Norwich Superior Court. He was not transported because he didn't have a bond. He was out on non-surety bond and did not know that there was a remand on my client. So on March 13th of 2024, they looked at the paperwork and they said a whopping $50 bonds just so he has a minimus to get him to court on April 3rd of 2025. So that's where we are regarding the seriousness of that charge. Once again, we're not disputing the fact that there is a case pending in court, which pretty 99% sure is going to get resolved on April 3rd. My client, as I indicated, was out in the community for approximately a year. He was working at Sally's Pizza prior to them opening the new location, West Farms Mall. He was working 40 to 50 hours a week. He was attending treatment at Wellmore 3 times a week for the alcohol. And I know the parole officer did put in her recommendation that, you know, he should be held until July. He was out. There's no hiding the fact that my client does struggle with alcohol. He is getting treatment for that. The other thing I want to bring to your attention is very important through my client is my client indicated to me he's never met with his parole officer since he's been placed at the halfway house. Is that correct, Mr. Alex?
So the charges and charge number.
Alex, hold on. I don't, gotta answer my question because I need to finish up. Have you actually met with your parole officer since you've been placed at the halfway house?
No.
Okay, so is it fair to say the allegations that are being brought against you that the parole officer writes, the information was passed on from the staff at the halfway house?
Yes, it is. Absolutely.
Okay. I just want to make sure that's part of the record. So once again, I know it's a 2-part hearing. We're not disputing charge number 3. I actually made a call to the court to find out what happened on March 13th to why my client was not transported to court. And I was advised it was a non-surety bond. And like I said, they didn't deem it that serious. They put a $50 bond on Mr. Raiford just so he can get to court on April 3rd. Okay. Is there something you want to add regarding the charges with the understanding, Alex? Anything you say here could potentially be used against you if there's a second hearing.
I understand.
Okay.
So again, in the charges of number 4, those charges were when I was in Renaissance East, all the urines and stuff, and I did adequate programming and I completed them. Every program that they asked me to go to, I completed them. And I was put on a bracelet and there was a lot of things, but all charge 4 was when I was in the halfway house. There is nothing recorded after I get to the connections house. There's nothing recorded, nothing at all.
And that's why I put on the record, those charges all occurred in 2024 and there was no issues. The last one you gave a volunteer statement was May 14th of 2024. So we're going, this May would have been a year that there's no violations with the alcohol stuff, according to the paperwork that was submitted. So you're correct. Thank you.
Yeah. Yes.
I don't have anything else to add.
I got one more thing.
Sure.
All right. So if you go to the reach bed policy, the stuff that I signed down on. So I got there 2/12/2025, right? So there are.
Alex, hold on one second. Let me cut. Is this regarding charge number 2? Your language for charge 2?
Yeah, it's around there.
No. If it's regarding charge number 2, I don't want you to say anything because I'm fairly confident what the outcome should be on charge number 2.
Okay. All right.
Okay. All right.
Yeah.
Thank you.
Okay, so council, any additional comments at this point?
No.
Well, can I go back to charge number 4 one more time?
Sure.
All right, so it's the connections paper. We're talking about the no consumption of alcohol beverages. Now, that was the halfway house in Waterbury, Connecticut. So now 212, I'm in her program at her house. My parole officer switched to Fortuna. Now the rules here, I was in that house for 19 days. The rules here, letter C, within 14 days, I will attend a substance abuse evaluation. As my parole officer, she was supposed to make sure that I was in a substance abuse evaluation intake within the 14 days that I was there. I was there for 19 days. Nothing was done. 19 on the connections, the rules of the house. Number 19, I understand I must participate in breathalyzer testings whenever asked. Number 20, I understand that I must provide urine specimens and mouth swabs when requested by staff. Now, the house that I was in, there's no staff, there's no nothing, there's no any of that. So all these rules, it's like, I never, what they were supposed to do for me, that never happened on their end. So, yeah, that's what I wanted to say about that too. Because if it was filed, if there was things done correctly, they would have had breathalyzers on me, they would have had urines on me, they would have had something on me from their program. They don't have nothing on me since I left the halfway house.
Correct. And that you're absolutely correct on that. Thank you.
Thank you. Just want to take a moment. I'll let you know my findings. Okay, so for charge number 1, the condition of curfew, making a finding of probable cause based on the state's exhibits B, D, F, and G. Charge number 2, the condition of program participation, making a no finding of probable cause based on the fact that the state did not submit sufficient evidence in support of the charge. For charge number 3, condition of obedience to the law, I'm making a finding of probable cause based on exhibits B, D, and F. And on charge number 4, condition no consumption of alcoholic beverages, I am making a finding of probable cause based on state's exhibits B, D, H, I, J, K, L, and F. So with that, I'm also finding that the acts are serious enough to warrant a revocation. And I will be notifying, So I am finding that the acts are serious enough to warrant revocation, and I've also determined that you should be detained while you wait for your revocation hearing. So we'll notify the records office, and your revocation hearing will be scheduled upon the disposition of your pending charges. So once that matter is concluded in court, we'll bring you back in for that revocation hearing. Okay. Do you have any questions at this point, Mr. Raiford?
No.
Alex, I'll set up another call with you after you resolve your case. Once I see what happens, we'll have a chat before the revocation hearing, okay?
Correct?
Yeah, April 4th, 3.
4-3.
Yes. All right, I'll talk to you soon, Alex.
Okay, this concludes the preliminary hearing for Alex Raiford and main number 363662. All right, thank you, Mr. Raiford.
All right, thank you.
Good morning, how are you? Oh, wait, actually, may we please see Ms. Ekbergh-Peek first?
Sure.
Yeah, we can't hear you. Yeah.
Can you hear me now?
Is that how you say it? Ekbergh-Peek? Ekbergh-Peek?
Officer
Ekbergh-Peek.
Trusello, I can hear York.
That's the way I pronounce it.
Officer Trusello, do you hear me?
Good.
I don't know.
Oh. All right. Good morning. Yeah, we still can't hear you. Huh, Miss Benedict?
Yes. Is this Ms.
It doesn't look
Ekbergh-Peek?
like they're muted, does it?
They can't hear me.
York, can you hear me?
Can you guys hear us?
Can you hear us now?
Yes, yeah.
Can you hear us now?
Oh, can you see us? They can hear
Yeah.
us, can't they? You heard me say an orange jumpsuit is nothing good. I'm still alive.
Yeah.
York, can you hear us?
We can hear you.
Oh, we can hear you.
Perfect, we can hear you now as well. Thank you.
Thank
Okay.
you.
Great. So we're gonna get started now. Okay, is this recording? No. All right, good morning. I'm Parole Officer Chisella. I'm a hearing examiner for the Board of Pardons and Paroles. And this is a revocation hearing concerning Annika Ekbergh-Peek, inmate number 315188. Today is Thursday, March 20th, 2025. And this hearing is being conducted via video at the Board of Pardons and Paroles Central Office in New York Correctional Institution. Can you please state your full name and DOC inmate number for the record?
My name is Annika Elizabeth Ekbergh-Peek, number 315188.
Thank you. So this is a public hearing and public access to this hearing is available via video live stream. Present this morning is Attorney Sirica. Can you please identify yourself for the record?
Sure. Attorney Alfonzo Sirica, public defender with the Parole Revocation Unit, on behalf of Ms. Ekbergh-Peek this morning.
Thank you. So this is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of facts as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence, and that is the better or weightier evidence must establish that more probably than not the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. And if I recommend a revocation, I will make a recommendation as to the appropriate sanction. My recommendation will then be given to a panel for a final decision, and if the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. You should know that a revocation hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing will be taken under oath. So, Ms. Ekbergh-Peek, can you please raise your right hand? You solemnly swear, solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God or upon penalty of perjury.
I do.
Thank you. So we're going to go over the procedure for today's hearing. First, I'm going to read you your rights. Then we'll review the parole violation charges that the state, your parole officer, is bringing against you. We'll then review and identify the exhibits filed for the record. The state is not present at today's proceedings. However, you will have an opportunity to present any relevant testimony and any relevant documents. After considering all the evidence presented, I will announce my findings. And if I find that you violated one or more of the conditions of your parole, you'll have the opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
I do not.
So you do have important rights at today's hearing, and we're going to review them now. Your first right is that you have the right to be represented by an attorney, and counsel is here present for you. You also have the right to receive written notice of charges of violation. Did you receive that written notice?
I did.
Great. So you also have the right to review the evidence against you before this hearing. You have the right to submit evidence in support of your case. You have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
I do, and I am.
So we're now going to review the charges that the state that your parole officer is bringing against you and the information underlying each charge. So on charge number 1, condition of residence, the charging officer reported that on 10/29/2024, you were released from York CI and placed at Stillman Halfway House in Hartford after your special parole was reinstated. At this time, Stillman Halfway House was your only approved residence. On 10/29/2024, the same day you were placed at Stillman Halfway House, you told staff you were leaving and walked out the door and got into a vehicle without permission from staff or your assigned parole officer. You made no attempts to contact Halfway House staff or your parole officer. To date, your whereabouts in the community were unknown, and based on your actions, you're in violation of release direction residence. On charge number 2, condition of absconder, the charging officer reported that on 10/29/2024, you were released from York CI and placed at Stillman Halfway House in Hartford after your special parole was reinstated. At this time, Stillman Halfway House was your only approved residence. On 10/29/2024, the same day you were placed at Stillman Halfway House, you told staff you were leaving and walked out the door and got into a vehicle without permission from staff or your assigned parole officer. You made no attempts to contact Halfway House staff or your parole officer. To date, your whereabouts in the community were unknown, and based on your actions, you're in violation of release direction absconder. On charge number 3, condition of obedience to the law, the charging officer reported that on 11/16/2024, you were arrested by Stratford Police Department and charged with criminal impersonation in violation of Connecticut General Statute 53A-130 and interfering with an officer, in violation of Connecticut General Statute 53A-167A. You were issued a promise to appear in court with a court hearing date of 12/4/2024. The state has filed the following exhibits that have been marked for identification purposes. I have Exhibit A, the parole, the special parole acknowledgement agreement. Exhibit B, the Connecticut remand to custody order. Exhibit C, the notice of parole violation. Exhibit D, the parole violation report. Exhibit E, the notice of parolee rights. Exhibit F, the Halfway House agreement, Stillman Halfway House. Exhibit G, the Stillman Halfway House incident report. Exhibit H, the revocation summary. Exhibit I, the decision summary. And Exhibit J, the Stratford Police Report number 240027693. In addition, the state has filed 2 addendums to the parole violation report, both which are also admitted as evidence. The first one was submitted on 11/18/2024 and states that on 10/31/2024, the board issued a warrant based on the report declaring Ekbergh-Peek an absconder from parole supervision. On November 16, 2024, she was apprehended by the Stratford Police Department and charged with criminal impersonation and interfering with an officer. And they noted that this is Ekbergh-Peek's 4th time absconding from special parole supervision since her discharge to special parole on September 7, 2022. In addition to her 4 absconding, she also escaped from community release from March 4th, 2022. Ekbergh-Peek's absconding history is as follows: abscond on 10/30/2022, return to custody on 3/6/23, abscond on 4/25/23, return to custody on 5/14/23. Abscond on 12/4/23, return to custody on 1/29/24, and abscond on 10/31/24, return to custody on 11/16/2024. The second addendum was submitted on 2/18/2024 and states that on February 13, 2025, Ekbergh-Peek appeared in GA2 Bridgeport Superior Court and was convicted of criminal impersonation. And sentenced to unconditional discharge, and the charge of interfering with an officer was nollied. So, counsel, did you receive the notice of parole violation, the parole violation report, and all the other documents identified?
Yes, I did.
Great. And I did also receive a defense exhibit 1, a list of parole accomplishments and future plans for parole statement. Is that accurate?
That's accurate.
All right. Need any more time to submit other evidence?
No.
Okay, so we don't have any witnesses today. So at this time, it is the defense's opportunity to call any witnesses, present evidence, and speak to the charges and the evidence.
Yes, first part of the hearing will be very brief, kind of self-explanatory what happened here. Just do want to put on the record for charge number 3 under obedience to the law. That addendum is correct. She did appear in court. The case was disposed of shown February 13th, 2025. The criminal impersonation was an unconditional discharge, not getting any jail time, probation, or anything like that. And the interfering charge was not. That is correct. That's my brief comment regarding part number one, but I do want to be heard regarding the situation for the second part of the hearing.
Thank you. Okay, so I have reviewed all the evidence. I've listened to the testimony at today's hearing. So with that, Ms. Ekbergh-Peek, I am finding that you violated the condition of residence based on the evidence presented in exhibits A, D, and G. On charge number 2, I found that you violated the condition of absconder based on the evidence presented in exhibits A, D, and G. And on charge number 3, I find that you violated the condition of obedience to the law based on your conviction of criminal impersonation on 2/13/25 when you were sentenced to unconditional discharge, as well as states exhibits A, D, and J. So that does conclude the fact-finding portion of today's hearing. Before I make my recommendation, you'll have an opportunity to speak to your background and history, and the purpose of this part of the revocation hearing is to help determine what outcome I recommend. Counsel?
Yes, on behalf of Ms. Peek, I'm not going to sugarcoat this. And I did have a frank conversation with my client. As you can see under charge number 1, that was the same day she was placed at the halfway house is the same day she left the halfway house. The issue here is Ms. Peek. She knows what's right. She knows what's wrong. She does have some severe mental health disabilities. I'm not making excuses for her, but there's another individual. I understand he's not the one here in front of you that's going to be sanctioned on this. It's going to be Ms. Peek. But this same individual that was previously involved when I've represented her in the past. I know his name is in the police report. I'm not going to put his name on the record, but the initials BR are going to go on the record. As I indicated to Ms. Peek, he seems to be one of the roots of her problems. And just to put on the record, it's fair game because his name is in the police report. And he's the individual that was involved on November 16th of 2024. He's the one that was driving a stolen vehicle. It was not my client. This particular individual currently, this is as of yesterday, so this information is relatively up to date. He has 10 cases currently pending in court with bonds totaling $350,000 cash assurance. Obviously, he's incarcerated. It's probably the best thing that's happened for my client because this individual that influences my client with severe mental health disabilities keeps getting her jammed up, and she could potentially be jammed up until 2033. That's when her OS date is. So you see this pattern of absconding. I'm not making excuses for her. That's not my role here. I just want to explain to you, when you have someone that has such an influence on you, she's lost 3 family members at the end of 2023. She lost her mother, she's incarcerated. She lost her grandmother and her grandfather. So you have this one individual who has all that influence over her. She's 40 years old. Like I said, she knows what's right. She knows what's wrong. But this guy is ruining her life. So he's going to be locked up for a lot longer than hopefully when she gets reinstated at some point. So I had that conversation and cleared that up with her as to what she needs to do. So regarding Ms. P, she's 40 years old. She was born in California and then moved to Naugatuck, Connecticut. She was placed at that halfway house. You see what day she left. She did take some education classes at Naugatuck Valley Community College. She also took some general studies at York through Middlesex Community College with Wesleyan's University Center for the Prison Education Program. That indicated due to her mental health issues, she does not have a work history per se because of that. And she did begin to file the paperwork for disability benefits for mental health purposes. She did appears October to November 2024, did receive some medication-assisted treatment, methadone with a counselor at the Liberation Program for a couple of weeks in Bridgeport. She also did some substance abuse IOP in Bridgeport. And also, it looks like a couple of years ago at Recovery Network of Programs, J Brothers in Bridgeport. Through my social worker, we actually received documentation which stated she did attend intensive IOP. She attended Monday, Tuesdays, and Thursdays from 10:30 to 1:30. Client had open lines of communication, interacted with her peers during her sessions. client completed a mental health evaluation and was prescribed medication while in treatment. So she is trying, but I think the X factor that's currently locked up is gonna help her when she's back out in the community. Like I said, she has until 2023, so there's plenty of time for her to come back here if she chooses to. It's gonna be a pattern. So once we take that factor out of the picture, I think she'll be a little more successful in the community. So she's been incarcerated, as it indicates, she does receive medication-assisted treatment, methadone, participates in that group once a week, medication compliant. She did sign up for tier 1 and 12-step meetings and is on the wait list for school. She's interested in the culinary or hospitality field. As far as housing for reinstatement, I don't know how this is going to play out. My client knows what she needs. She's asking to be placed in an inpatient mental health program. I don't know how the field parole is going to deal with that, but that was at my client's request. And obviously I have to put that on the record because that's what she asked for. As far as education, she does want to obtain her ServSafe certification, enroll in culinary or the hospitality program, and she hopes one day to get a degree in psychology. She is going to finish the paperwork for the disability and is interested in working part-time in the restaurant industry once she obtains her safe certification. Is amenable to any treatment recommendation. Like I said, typically our clients tell us what they did, but my social worker was able to actually get documentation from the provider. So what I put on the record was verified. Okay, I just want to make sure that's clear. Ms. Peek, anything you want to add? I not trying to put you down. That's not my purpose here today, but I have to be frank on the record to try to help you here. So you know what happened on October 29th and how long you lasted out in the community, and Mr. Sella can read. So it's not like we can hide what happened here, okay? It's up to you now because you can't blame it on PR anymore because he's gonna be in for a lot longer, hopefully, that you're gonna be. So you're gonna be back out in the community, hopefully without his influence. So you need to get your act together. Because as you know, as I already put on the record, you're on supervision until 2033. You've been back here a couple of times already and I've represented you. And what I'm putting on here is nothing that is a surprise to her. She has the same documents I have. So anything you want to add about what you're going to do once you get back out?
I just want to say that I do plan on not repeating the same thing. I want to, as I said, I really think that if I went to some sort of mental health program, that would be good for me. I don't know what kind of options are available, but if that does not happen, I am not going to be repeating the same behavior. I want to be successful. I don't want to keep repeating this behavior. I am very, very tired of coming to this place, of wasting the state's time, of wasting your time and everybody's time, my parole officer's time, making people chase me, being chased. I just want to be a normal person. I do not want to keep doing this. I want to come out and just continue doing what I did once before. When I came out, I was able to go into inpatient, into IOP, and I was doing well. And I was on my medication, and I want to get my disability and be able to go to school and then work or volunteer somewhere. And I just want to stay busy so that I have a schedule and I stay on track. I don't want to keep doing this. And that's all I have to say. Thank you.
Council, any further?
I don't have anything else to add. I just want to say she was indicated on track at some point here, but she keeps doing the same thing over and over. And at some point, she needs to stay on track based on the length of supervision she has left. But I keep repeating myself, I think that negative influence is incarcerated and it's hopefully going to help her stay on track. Like I said, we did actually receive documentation. She was on track and doing very well. So she's capable of doing it. Thank you.
Thank you. So I don't have to reiterate all of the statements because we've heard it in the addendum. Council has said it over and over again. The behavior is just a pattern this week, so it's very concerning. And I do appreciate your statement that you're tired. I can only imagine being tired from it as well. But at the same time, your actions have just not shown it. So with that being said, I am going to recommend that your parole be revoked and that you serve an approximate 18-month period of confinement as a sanction. That's with the re-parole date of May 16th, 2026. And I'm going to recommend the following conditions: no alcoholic beverage consumption, no contact with victims ME without parole officer's permission, and a mental health treatment. I do need a halfway house location because we don't place straight into mental health inpatient. So what would your location be for your halfway house?
Bridgeport.
Bridgeport. But what I can recommend to you, Ms. Peek, is that when you get out, stay long enough and have the conversation with that parole officer to get you into that program.
Okay.
Just give yourself you have to give yourself the opportunity because the resources are out there and available, but you have to give yourself the time and get to some treatment that'll be beneficial to you. Okay.
Okay.
So that is my recommendation. It's going to the board on April 3rd, 2025, and you'll receive a written decision from them shortly after. So on that date in April, the board can do three things. They can lessen my recommended sanction, they can adopt my recommended sanction, or they can ask to see you for a supplemental hearing if they have concerns and want to impose a sanction longer than what I've recommended. If that is the case, you'll be notified of that hearing because you'll be present for it and you'll answer their questions and concerns. Okay. Any questions at this point?
So Ms. Peek, on April 3rd, the board meets, you and I will get something in writing about 7 to 10 days later with the final outcome. If there's an issue with them adopting the recommendation, I'll set up a call with you and explain the next step to you. Okay.
Okay.
All right. Good luck to you.
Thank you.
The revocation for Annika Ekbergh-Peek, inmate number 315118. Thank you, Ms. Peek. Good luck to you.
Thank you.
Hi again.
Can you hear me?
Yeah,
Which brother do you know? I have more than one.
I know. I'm sorry. That was probably really inappropriate. Rob.
Oh.
Are you all ready for the next one?
Who do you know?
Yes.
Thomas.
Okay.
I'll email you.
All right. Perfect. He says, doesn't really come. Thank you.
Have a good day.
Appreciate that touch.
All right, ready? We're all here. Okay. So good. Is it morning still? No, it's afternoon. Good afternoon. I'm Parole Officer Trusello, and I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Amanda Fitzgerald, inmate number 373325. Today is Thursday, March 20th, 2025, and this hearing is being conducted via video at the Board of Pardons and Paroles Central Office and your correctional institution. Can you please say your full name and DOC inmate number for the record?
Amanda Fitzgerald, 373325.
Thank you. So this is a public hearing and public access to this hearing is available via video live stream. Present this morning is Parole Officer DeJohn. Can you please identify yourself for the record?
Hi, Alyssa DeJohn, Parole Officer, WRU.
Thank you. So this is a preliminary hearing which has three purposes under Connecticut law. The first is to determine if there is probable cause to believe you committed an act that violated the conditions of your parole. The second is to determine if the act is sufficiently serious to warrant the revocation of your parole. And the third is to determine if you should be held in prison pending further proceedings. The state, not you, has a responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I do find probable cause and determine the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding, and anything you say at this hearing can be used against you. This hearing is also being recorded. The testimony at today's hearing is going to be taken under oath. So Ms. Fitzgerald and Officer DeJohn, can you please raise your right hands? You solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, nothing but the truth, so help you God, or upon penalty of perjury.
I do.
Thank you. So we're going to go over the procedure for today's hearing. First, I'm going to read you your rights. Then we're going to review the parole violation charges that the state, your parole officer, is bringing against you. The state will then have an opportunity to address the issue of probable cause and the severity of the allegations. And after the state is finished, you will have the same opportunity. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No.
So you do have important rights at today's hearing, and we're going to review them now. The first right you have is you have the right to be represented by an attorney at this hearing. You may hire your own attorney, and if you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Were you informed that an attorney could represent you at today's hearing?
Yeah, I sent the letter back to be appointed one.
To be appointed, okay. So does that mean that you want to continue today's hearing to hear back from them?
Yes, please, if that's possible.
Okay, when, do you know when you sent that letter? Did you send them the application?
I sent them the application as soon as I got it.
Send application back.
Do you want me to look at the file?
If you have any records of it, because you would have sent it to the parole revocation unit, correct, in Waterbury?
Yes, in Waterbury.
Received.
You, yeah, on the notice of parolee rights, you said, it said number 2, would you like to be screened to determine if you are eligible for an appointed attorney? You said no.
I said no.
Yeah.
That, I mean, you have the right to change your mind today, 100%. So Ms. Fitzgerald, would you like a continuance of today's hearing so you can obtain that?
I would like one, yes.
Okay, no problem. So my next hearing date is April 7th. So that actually gives enough time for this to all work out in that way. So I'm going to continue your case today till April 7th for you to obtain an attorney. I will just let my boss know that you have asked for one, so maybe we can reach out to Prue to see if they got that application from you as well, okay? Any questions right now before we conclude?
I just don't really know how this all works.
Okay, so yeah, so then it's in your best interest then to speak with an attorney and get representation for it. Officer DeJohn, would you like to be present on April 7th?
Yes.
Okay, so is there any way you could reach out to me, like for a legal call? I would like to speak to you.
I don't know. Let me find out. Okay.
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 Okay, so I am gonna continue today's hearing based on Ms. Fitzgerald's request for counsel, and I will see you on April 7th. Okay, all right, thank you, ladies. Have a good day.
You too.